A blessed day, everyone. My name is Guadalquiver, and for today's topic, we will be going to tackle about the Chapter 5, Law on Sales Agency and Credit Transactions. So for the learning objectives, we have to describe and explain the nature of sales transactions, identify the functions and operation of agencies in the industry, and identify ways of handling credit transactions. So for the content, number 1, introduction. Number 2, characteristics of a contract of sale. Number 3, effect of loss of the object in a contract sale. Number 4, sale of personal property payable in installments. Number 5, pacto de retro sale or conventional redemption. Number 6, obligations of the vendor. Number 7, obligations of the vendee. Number 8, liability of the principal and the agent. Number 9, simple loan or mutum. And lastly, number 10, pactum commissorium. The tourism, travel, and hospitality industry frequently encounters contracts, including sales contracts. Understanding these contracts and their potential breaches can provide an overview of sales transactions and remedies. So at this juncture, let's break down the 7 characteristics of a contract of sale. So number 1, we have consensual. A contract of sale is formed by the agreement or consent of the parties involved. No specific form is required except in certain cases. So if, for example, if we want to sell a house, the agreement must be in writing to be enforceable. Number 2, we have the bilateral. A contract of sale creates mutual obligations between the buyer and seller. Both parties have responsibilities. So for instance, when you buy a car, you have the obligation to pay the agreed price, and the seller has the duty to deliver the car to you. So the next is the principal. A contract of sale is a standalone agreement and does not depend on another contract. It is complete in itself. So for instance, if you sell a piece of furniture, the sale agreement is independent and does not require any additional contracts. Next, number 4 is the onerous. In a contract of sale, both parties receive something of value. The seller delivers the item and the buyer pays the price. It involves an exchange of benefits. So for example, when you purchase a laptop, you give the seller money and they gave you the laptop. Number 5 is the commutative. The value of what the seller provides is considered equal to the price paid by the buyer. In other words, there is a fair and balanced exchange. So for example, if you sell a book for $10, both you and the buyer believe that the book's value is worth $10. Next, number 6 is the nominate. The term sale is specifically used to describe this type of contract under the Civil Code of the Philippines. It has its own designated name. So for instance, when you enter into agreement to sell a piece of land, it is referred to as a sale according to the law. So, and this lastly, the transmissive of ownership. In a contract of sale, the seller transfers ownership of the item to the buyer. This means that the buyer becomes the rightful owner of the purchased item. So for example, when you buy a painting, the artist transfers the ownership of the artwork to you. Effects of loss in the object in a contract of sale. Article 1480. Any injury to or benefit from the thing sold after the contract has been perfected, from the moment of the perfection of the contract to the time of delivery, shall be governed by Article 1262. For example, nag-agree ka nga mopalit ka og brand new nga laptop sa isa ka store. After nga ni-agree ka nga paliton ang laptop, accidentally someone scratches the laptop. So, what will happen is, the buyer is responsible for the damage, not the seller. Kaya human naman sila agree and pay sa product. And this Article 1262 An obligation which consists in the delivery of determinate thing shall be extinguished if it should be lost or destroyed without the fault of the debtor and before he has incurred in delay. So, let's say nipalit kag new bicycle from a store. Then, a bicycle na damaged before it is delivered to the buyer. So, probably, the seller is responsible for the damage and need gud mag-provide og another new bicycle para sa buyer. And the next article here is the 1496. The ownership of the thing sold is acquired by the vendee from the moment it is delivered to him in any manner of the ways specified in Article 1497 to 1501, or any other manner signifying an agreement that the possession is transferred from the vendor to the vendee. So for example, continuation sa example sa bicycle. So, once the bicycle is delivered to the buyer, the ownership of the bicycle is transferred to the buyer. So at this moment, we are now on sale of personal property payable installment. Article 1484, in a contract of sale of personal property, the price of which is payable in installments, the vendor may exercise any of the following remedies. First, exact fulfillment of the obligations should the vendee fail to pay. So if the buyer or the vendee fails to pay an installment, the seller has the right to demand full payment of the remaining installment. In simpler terms, the seller can insist that the buyer pays the remaining amount owed as per the original agreement. Next is the cancel the sale should the vendee's failure to pay cover 2 or more installments. If the buyer misses payments for 2 or more installments, the seller can choose to cancel the sale. This means that the seller can terminate the contract and take back the sold item. And lastly, foreclose the chattel mortgage on the thing sold. If one has been constituted, should the vendee's failure to pay cover 2 or more installments. If there is a chattel mortgage, a loan secured by personal property on the sold item and the buyer defaults on 2 or more installments, the seller can foreclose on the mortgage. This allows the seller to repossess the item to recover the outstanding debt. Next is the pacto de retro sale, or conventional redemption. Article 1601, conventional redemption shall take place when the vendor reserves the right to repurchase the thing sold, with the obligation to comply with the provisions of Article 1616 and other stipulations which may have been agreed upon. So for example, ikaw na kay land og nanginhanglan ka og kwarta. Naka-decide ka nga ibaligya ang yuta sa imong friend, but gusto nimo nga naay choice nga mapalit nimo usab kung mahimo nimo. So, imong giapil ang clause, ang isa ka clause sa kasabutan sa pagbaligya na nga nag-state nga ikaw naay right sa pagpalit pag-usab sa yuta. Sud sa let's say isa ka tuig, with the same price nga imong gibaligya sa imong friend. Ang imong friend di agree og ang pagbaligya nagpadayon. So, after 6 months, you manage to gather the funds og naka-decide ka nga paliton og balik ang yuta. Because of the conventional redemption clause nga giapil sa agreement, you have the legal right nga paliton og balik ang yuta from your friend for the original price. Next is the obligations of the vendor. Article 1495, the vendor is bound to transfer the ownership of and deliver as well as warrant the thing which is the object of the sale. This means not only handing over the physical possessions but also ensuring that the legal ownership rights are transferred. So for example, if you sell your old bicycle to a friend, you are obligated to actually or physically give them the bike. Next article is 1496. The ownership of the thing sold is acquired by the vendee from the moment it is delivered to him. So this emphasizes the importance of the delivery process in completing the transfer of ownership. So this means that once your friend has the bike, it's theirs to use and keep. Next article is 1497. The thing sold shall be understood as delivered when it is placed in the control and possession of the vendee. This clarifies that the delivery is not just about physical movement, but also involves giving the buyer practical control and authority over the item. So in the case of the bike, your friend must have full control and possession of it for the delivery to be complete. Next is the obligations of the vendee. Article 1582. The vendee is bound to accept delivery and pay the price of the thing sold at the time and place stipulated on the contract. Let's say for example sa Shopee, i-deliver man jud na sa GNT ang parcel, which is the product. As the buyer, your responsibility is to be present to accept the delivery of the item when it arrives at your doorstep. Imuhang bayaran ang agreed price sa item either in advance or upon delivery. Liability of the principal and the agent. Article 1883. If an agent acts in his own name, the principal has no right of action against the person with whom the agent has contracted. Neither have such persons against the principal. So let's say you hire a personal shopper to buy groceries for you. If the shopper makes purchases in their own name, you can't sue the store or supplier they bought from. Either the stores or supplier can sue you because the personal shopper acted independently, and both parties are legally protected from each other's actions under the principles outlined in Article 1883. So next is a simple loan or mutuum. Article 1956. No interest shall be due unless it has been expressly stipulated in writing. In simple terms, when you lend someone something, like money or an item, without expecting to get the same thing back, it's called simple loan or mutuum. So let's say, imong gipautang og kwarta imong amiga to help them out with some expenses. You both agree nga ihara kang bayaran. But wala mo nagsabot or ga-discuss about sa interest being added to the amount. But some cases here sa atua, specifically in Philippines, mahimo nang quits ang utang because kalimtan naman lang ang utang. Thank you ra ibayad, which is very common nga issue sa atua, and it is called a simple loan or mutuum. And lastly, pactum commissurium. Article 2088. The creditor cannot appropriate the things given by way of pledge or mortgage, or dispose of them. Any stipulation to the contrary is null and void. Like when you give something valuable like property or jewelry as collateral for a loan, it's called a pledge or mortgage. This article says that the creditor, or the person you owe money to, cannot sell or take the pledge item if you fail to repay the loan. Any agreements that allow the creditor to do this is not valid. So for example, let's say you use your car as collateral to get a loan. If you can't repay the loan, the lender can't just take your car without going through the proper process. This law protects your rights and ensures that creditors can unfairly take your pledged items without following the law. And that is all about my report. I hope I delivered it clearly, and thank you for watching. Have a nice day ahead.